The views and opinions expressed during the following webinar are those of the individual contributors and do not necessarily reflect the official policy or position of the contributor's employer, organisation, committee, or other group or individual. Please respect any all contributions, and we encourage you to join the conversation via the interactive functions available. So, hello and welcome along to the ILC Personal Injury Reforms What's Next webinar. I'm Mark Hadaway, Managing Director of I Love Claims. I'll be handing you over very shortly to our hosts and panelists for today's session. But I first just wanted to say a huge thank you to our ILC corporate partners and insurer partners, the logos of which you've seen displayed on the opening show floor. Specifically today, I would like to express gratitude to our legal partners, Carpenters and Keoghs, a Davies business, for supporting this session. Today's session tackles a new and arguably unsettled subject matter, personal injury claim reforms. So not only are we extremely grateful to our panelists for sharing their insights and thoughts, but we would also like to ensure as many of you, the ILC community, also have input. Please, therefore, use the chat facility to share any comments, thoughts and feedback you may have, and please post any questions in the Q&A, both of which you will see on your screen. So without further ado, I'd like to hand over to our host for today's session, Chris Ashworth, founder and chairman of I Love Claims Motor.
Thank you, Mark, and good morning, everyone. Really appreciate you taking the time to join us on what I'm sure will be our first of a series of webinars as we figure out what's happening, what's going on, and what the future holds for the personal injury reforms. So I'm going to kick off by giving a brief introduction to our esteemed panel today. We always try to bring together a broad spectrum of views from across the motor claims industry. So hopefully you will be able to ask questions depending on your sector of your area of interest. And first up, we have a very familiar face to any of you that have watched any webinars during the course of the last 18 months. We're joined by Donna Scully, Director at the Carpenters Group. Donna's worked with various London law firms before joining Carpenters back in 1997, where she set up the Specialist Personal Injury Department, and Carpenters now is one of the leading insurance and legal services provider in the UK market. Donna was chairperson of the Motor Accident Solicitors Society, put my teeth back in for a 2-year term back in 2010. So good morning, Donna. Next joining us today for our first appearance on ILC is Peter Gomes, the CEO of the CHO. Peter was previously head of business and has now become CEO of the CHO, the organisation that was formed in 2010 from a merger of the Accident Management Association and the National Association of Credit Hire Organisations. Peter's previous experience in the claims world involved roles at Help Hire Ready plc and Track Global, where he was the CFO. Next, we have another familiar face at ILC Motor Conferences, bringing her expertise from the legal side, is Sam Ramen, Director at Keoghs, a Davies company these days. Sam's the client relationship partner for 2 of Keoghs' key insurer clients, and she's also responsible for leading the public affairs and thought leadership program, which includes keeping us informed with and influencing any policy development that may affect the insurance industry through liaising with representatives within government, Westminster, and other relevant industry stakeholders. So good morning, Sam. Next up, a view from the insurers. We've got Caroline Johnson, the Technical Director of Claims at LV, joining us this morning. Caroline's been Director of Technical Claims at LV since October 2017. Time flies, Caroline. Prior to which she spent 8 years as Head of Third-Party Claims and Technical Services at LV. Before joining LV, Caroline spent more than 17 years at RSA, also pursuing her clear passion for technical claims. And then last but by no means least, we have Matthew Maxwell Scott, who's the Executive Director of ACSO. Matthew has had a diverse career with insurers, claimant lawyers and others. He worked for 10 years for the Confederation of British Industry and has also been a local councillor and a parliamentary candidate. So good morning and welcome to ILC, Matthew. Right, so this has all been going on for about 5.5 years, Sam was saying on the pre-meet earlier. We've done lots of updates in our annual motor conference, normally around this time of year. So it would be remiss of us, Sam, not to let you take the stage and give us a quick recap and remind everybody where we are in the reforms journey.
Thanks very much, Chris. Hi, everyone. Good morning. So I'm just going to spend a few minutes now to give a little bit of context, I suppose, a bit of a reminder of the original objectives of this. It's been such a long time coming. We're finally here. But yes, just a reminder of where we were 5.5 years ago, when it was the Chancellor's Autumn Statement in 2015. George Osborne, remember him? That autumn statement had a very clear agenda at the time. It was to reduce the cost of living for households. And, you know, obviously motor insurance does form part of many households' average and annual costs. So this objective was to reduce the cost of motor insurance by about £40 to £50 a year. That was the original objective. That number has changed somewhat over the years, but kind of in that ballpark. And as Chris says, it has taken some time to get here, hasn't it? 5.5 years, consultations, stakeholder discussions, even legislation that was dropped due to general elections, if anybody remembers the Prisons and Courts Bill. Anyway, we're here now, despite Brexit and the pandemic causing delay after delay, we're here. And the policy did hold through successive Tory governments and through a string of different Justice Secretaries as well. So we've got the Civil Liability Act, which gained royal assent in December 2018. All of the required secondary legislation earlier this year pulled everything together. And last Monday, Robert Buckland hailed this piece of reform as the changes that will put an end to this greedy opportunism and ultimately see savings put back into the pockets of the country's drivers. The figures now used by the MOJ are up to £35. So slightly below the 40 to 50, but kind of in that region. So I think it's interesting to reflect because the objective still remains, doesn't it? This reform was brought about to benefit the premium paying public. And some might say, you know, with all of the struggles of the pandemic and the squeeze on household income for many now, this has really never been more important. So how will this work? You know, government are really keen to make sure that this is followed through. There will be checks and balances. There's a statutory provision here for insurers to report to the FCA on savings, and Part 3 of the Civil Liability Act requires that. And insurers will need to demonstrate how the savings from the reforms have been passed on to customers. And thereafter, Treasury will report to Parliament after April 2024 and will give a view on whether and how policyholders have benefited from any reduction in costs for insurers. Now, many of you will know just from, you know, kind of general trade media and kind of discussions over the virtual water cooler, it would be these days, that there is some skepticism about this. Indeed, many of you may have some skepticism about this, about whether these savings will be passed on. But I think it's really important to remember motor insurance is an incredibly competitive market. And, you know, kind of economics really dictates that savings will be passed on. Otherwise, insurers will price themselves out of the market. So we would hope to see that this policy objective is achieved. But of course, and as I'm sure we will discuss in some detail today, there's quite a lot to do, a lot to work with and to work out in the interim before we get there. So my quick kind of 2, 3, 4 minute run through, Chris, just with that sort of reminder of why and how we got here.
Thank you, Sam. I remember the Prisons Bill like it was only yesterday. So let's kick off then by going round the table, and I will ask you to give a high-level overview on the reforms from your personal and sector perspective. So I'm going to kick us off with Peter. Can you just give us a quick view from the CHO perspective?
Yes, from the CHO's perspective, I guess the focus is more likely to be on developments for Part 2. But looking at Part 1, I think we have to step back and say, what was part one designed to achieve? And in that context, as Sam has outlined, it's a reduction to the benefit of the consumer, numbers banded around between £35 and £50. And the question that arises in my mind is, how is that saving actually going to come about? And how are insurers going to demonstrate to the benefit of the consumer that here's your £35 back, without taking advantage of, for example, reduced claims rate because of reduced traffic volumes in the wake of the pandemic. And we don't yet know how things are going to unfold with hybrid working once we come out of the impact of COVID. But I think a key focus, for example, on part of the media will be being able to demonstrate that the benefits have accrued and the £35 has gone back into the pockets of consumers.
Interesting. I definitely want to talk to you, Caroline, about the complexities of, I guess, quantifying those savings and how those will play back. So let's hold that thought for now. But Caroline, why don't you say hi to everyone and give us your thoughts from an insurer's chair?
Hi, morning everyone. I think from an insurance perspective, clearly the reforms are something that we are very, very supportive of. It has been a number of years where we have seen ever increasing numbers of whiplash claims at ever increasing values. So I think from an insurance perspective, it's been a long time coming, in the 5.5 years, and to some extent the original intentions have been watered down, as often happens with the level of detail that you get into with the reforms. But I think for me it's very much about making sure that the benefits are absolutely passed on to consumers, and I think there's an absolute passion to do that. We are regulated by the FCA, as everybody knows, and the FCA are very keen to understand from each insurer how those savings are calculated and demonstrated that they have actually been passed on to the consumer. I think the other thing for me is just I'm not sure how aware the consumers still are of these changes. I'm not sure that there's been a huge amount of knowledge sharing coming out, and actually, I've seen some research that consumers don't really necessarily understand what is happening or the benefits that are coming from it. So I still think there is a piece to do in terms of educating of consumers, both in terms of the impact to them as individuals and or claimants, but also just understanding the value they should bring and will bring to their premiums.
Thanks, Caroline. Donna, good morning.
Good morning. Morning, everybody. Well, I'm going to look at fraud, really, and how when it all started 5.5 years ago, there was, a hope and a thought that we were going to look at, this is an anti-fraud exercise. I understand that reform can be a positive thing. It can, help the industry. It can do good things. But I sort of look at it and say, well, from a fraud perspective, we sort of lost sight of that along the way. And I don't think even now it's talked about. I mean, I suppose in a way we talk about reducing claims, reducing the cost of whiplash. So that's sort of there or in the sort of fraud space. But I think for me, my big disappointment was, after the fraud task force did these recommendations and got the industry together, and we had a big plan to make things better and to work better in the anti-fraud space. That never got off the ground. And then these reforms have sort of lost their way in terms of fraud. So I sort of look at it now and look at how it's going to work, or how we think it's going to work. And I go, is it going to reduce fraud? I mean, it's a frictionless process. I don't know how likely it is that people are going to use it themselves, or we're going to have representatives there. But I just think it's probably got less fraud checks than we had before. I think there's probably more scope for fraud. So that would be my very big disappointment in relation to the reforms at the moment. But we'll see how they pan out.
Thanks, Donna. We'll come on to some of the, I guess, other potential and intended consequences. But Matthew, just give us a bit more of an overview on ACSO and how you guys are tackling the current situation.
Sure. Thanks, Chris. Morning, everyone. I'm delighted to be with you. So the Association of Consumer Support Organisations that combined with my name is a bit of a mouthful, so my apologies. So ACSO, anyway. We represent claimants in the civil justice system. We're a membership organisation. Our members are claimant lawyers, medical reporting organisations, credit hire, rehab firms, basically all the different organisations that consumers rely on in the event that they make a claim. It doesn't have to be a personal injury claim, but obviously, or indeed an RTA one, but in terms of what we're discussing today, that is their focus. Look, I've been living and breathing these reforms for more than 5 years. In fact, in the 2017 general election, I was running for Parliament for the Tories and ran on a pledge to deliver them. So I lost, so therefore I don't have to stand up for them. I was delighted to see the disclaimer, or hear Mark's disclaimer at the beginning of this session, saying these views are strictly mine, not my organisation. So I can say what I want, but I'm at the I Love Claims lunch on the 2nd of July. I hope it happens. Hugely looking forward to it. If any of you are there and want to take me to task for anything I say, please do. Let's do it over a well-deserved drink. Look, I think that these reforms are with us. I think there are some serious flaws in the thinking behind them. I've never said differently. The claims numbers that Caroline mentioned have fallen pretty dramatically over the last 5 to 10 years. And certainly that's a fall that's been hugely increased by the impacts of the pandemic. That may not be a permanent fall. In the last full year before the pandemic, 2019, about 670,000 claims. The MOJ is predicting 400,000 claims a year under the new system. So that's a very big fall. I wonder whether the money will be passed on to consumers, but I think insurers have got 3 years to work this one out. And frankly, if you can't over that time work out how to demonstrate these have passed on savings to consumers, get yourself some better accountants, frankly. And just on, we've got lots to discuss, but on Donna's point about fraud, she's quite right. I mean, this was when George Osborne stood up and made these original plans. Anti-fraud measures were very much part of it. I think, though, that the tariff, which means that the compensation available to consumers is so dramatically lower, that means that there is a considerable disincentive to fraud that there was before. And also, of course, let's not forget the ban on pre-med offers. Data on how well these were used by insurers is a little bit sketchy. But I think you don't have to be a claims expert to work out there was an incentive to fraud there if you could make a claim without even having to prove you were injured in the first place. So I think that's a welcome development. That's legislated for in the Civil Liability Act too. So I hope we're going to see some positive impact from it. I hope it's going to work. Of course I do. I mean, look at us. We're all here. There's 200 of us here, at an online conference. A couple of years ago, we would have thought that's impossible. So the idea that we can do a smooth claims process online, perhaps without legal assistance, it's not that fanciful. We can't yet know what is happening with the official injury claims portal. Anecdotal evidence is that it's having a difficult first couple of weeks, but I think you'd expect that. And let's be reasonable and hope that it can learn from any teething problems and improve. But we've got a long time ahead of us before the savings point becomes clear, 3 years. But I think probably over the next maybe 6 to 12 months, we'll see it bed in. We'll start to see the impact in terms of claims numbers, possibly fraud. There's no reliable fraud data is my concern on this, and no verifiable fraud data. But we may well hear some more about how consumers are responding to this. And Caroline's spot on. There's been no comms plans on this at all. People don't know about it. The only time they'll find out is at a point when they try and make a claim. Therefore, there is a big reputational issue, I think, for insurers particularly. This was an insurance industry plan. It's been delivered by the insurance industry. And so people may justifiably, if they have a bad experience when trying to make a claim, wonder why the insurers were doing what they're doing. So, yeah, lots to discuss. Really looking forward to the rest of it.
Interesting, and as you rightly say, it's probably far too soon to have any kind of hard data in terms of how the portal's working. We've all had the benefit of webinars and videos from the MIB in terms of how the portal works. We're not involved in that process in my day job, but I couldn't help but have a little look, and it seemed hellishly complicated for somebody who's spent a long time in claims and is reasonably tech savvy. So Donna, I'm going to turn to you first as a big player in this market. the portal. How's it going from a day-to-day business perspective so far? And what are your thoughts in terms of how easy this is for consumers to actually use?
I suppose the starting point, I'd say a lot of people watching today who are doing it on the ground or have prepared for this will be a bit wary, but trying to be get the right word, but trying to be full of optimism. I mean, this has been a long time in the making, and the start date happens to be in the middle of a pandemic when people are working at home. Not the easiest time really for everybody, but it is what it is, and here we are. I agree with Matthew. I think the system looks pretty good as a system. I think we would have all liked to see more live testing because there are bugs. I think, one of our concerns at the moment is when you notify the MIB about bugs, there's no SLAs for return or no timescale for when they're going to be dealt with. So that's a bit of a black hole at the moment. So, but, we don't want to throw stones because we might get things back quickly and they might respond quickly. So, as you say, it's very early days. I think your point on who's going to use this, I mean, I've seen a sign of kind of a change of tone recently in terms of that. I think, that this it was always called the LIP portal, wasn't it? The LIP portal, because it was going to be litigants in person. And it's the OIC portal, which is maybe just that's the name. But I think even in the when it was presented and it came into play recently, it was kind of talked about, people can use it or they can be represented on it. And I think, that there's definitely been a kind of a tide turn towards the likelihood is there's going to be more representation on here. And I think if you look at the rules and the protocols of over 200 pages, and then 2 weeks ago, we got the guide, which is 60 pages. I don't know if you've had a look at it, Chris.
That's the guide for the consumer, right?
Yeah,
it's a 60-page guide for a consumer.
Yeah, it's chunky. And I was doing one of these webinars the next morning after it came out, and I read it about 6 times because I thought I might get questions on it, and I found it really hard to work out. But it's chunky and it's complicated because there's lots of ifs and buts in an RTA claim, and they've put everything in there, so every scenario is in there. And I think the feeling is that what you do is, if you're running a claim, you only read the bit of the claim that you're doing. But I don't see how that can be the case, because how do you know as a consumer what to read or whatever? So I suspect looking at that, if I was looking at that and I wasn't a lawyer, and even as a lawyer, I find it complicated, I think I'd be looking for someone to help me. So I think that's one of the issues that we're going to see. I do think, we talked about this, I think, on previous seminars about PPI, and people got people to help them to do that. And it was really easy. It was quite straightforward, but they're prepared to give a chunk of their damages away to get it. So to get the help. So time will tell, and maybe it'll still be a success if there is still a huge amount of representation on it. And there'll still be the saving and everything will be okay. But I definitely see, looking at it myself, and we'll have to wait and see the outcome, that, will people do it themselves? I'm very skeptical about that. And will they be able to do it? Some of the issues at the moment in terms of double-barreled names, it doesn't like the number 5. Now, if I'm an individual, how do I deal with that? Whereas we have a big IT department, so we kind of can do a workaround. You can't do a hyphen, you can't do it, I think, an apostrophe if your name's O'Neill. So things like that, if I'm an individual, I just give up immediately, whereas we'll find a way in a workaround. So, and those things hopefully will be ironed out. So I don't want to dwell on them too much, but I don't think it's not looking that easy at the moment. So we'll see.
Apparently the double-barrel name piece was just specifically so Matthew couldn't pursue a claim.
I see.
Discrimination. I'm going to make a claim for that.
Vicious rumours. Caroline, it must have been a huge operational kind of heavy lift for an organisation of the size of LV. How's it gone? Talk to us in terms of operational implementation, training, and how you're seeing the first couple of weeks of claims flowing through the portal from an insurer's view.
Yeah, no, absolutely. I think it has been a huge challenge, not least because even sort of the rules being published have been quite late in the day as we've moved towards implementation. But we're actually in a pretty good place on it. We've set ourselves up with sort of specific teams so we can learn as we go, making sure that we kind of understand what we are seeing and how we can support claimants as they come through to us. And I think that also allows us to have some flexibility to be able to really respond to whatever behaviours or support we need to give us as we go through that process. So yeah, it's been pretty challenging. I think the system side of it has been quite challenging in terms of making sure that all of the systems are joined up for day one implementation, and that claims can actually be delivered, and that we can understand what's coming through the door. But again, we're okay with that, and we're in a pretty good place on it. I think in terms of what we've observed over the last week or two, we have seen fewer cases coming through than we expected. I think there have been a couple of glitches or challenges on the claimant solicitor side in some places, and the ability to actually put the claims through the portal. So we have seen, as I say, a reduced volume to that, even having taken into account COVID impacts. And we've seen about, at the moment, and it's very early days on very low volumes, but about 12% of the cases coming through to us are from direct claimants, unrepresented. So whether that will continue and what that looks like or develops out to, we will see over time, I guess. I think overall, operationally, it's gone reasonably well, very well. I think as I said earlier, my concern is probably just about understanding for consumers and claimants, and just making sure that there's that clear communication going out.
Thank you. And I'm sure it's down to your team leadership skills that you've implemented something so big so smoothly. So well done. I'm going to jump across to a question before I move on to ask Sam how it's going from a defendant law firm's perspective, which links back to Peter's earlier point and Sam's overview in terms of how this gets back to consumers. So I guess there's a moving feast here, isn't there? As always, which is, talking some insurers, they've been aggressively pricing in the benefits, which causes the market to follow before those, savings are actually realised. We've got a situation at the moment where people's cars, I think, are parked up a little bit more than they have been previously. So is there a overall reduction in frequency, and so on and so forth. So for me, other things that will impact the cost of claims. So I guess I'll split this question into two for you, Caroline, which is, how straightforward is it going to be for you to fulfill your obligation to the FCA to say, hey, here's the positive cost impact, assuming it's positive, that the reforms have had? And then I'll just segue on the question from one of our anonymous viewers, which is, and how are the public supposed to trust that number?
Okay, so I think they're very good questions. I think it was mentioned earlier, the kind of the market that we work in motor insurance is so competitive that if insurers don't pass on benefits, then they basically just won't get business. I think most insurers will, if not all, will already be taking a view as to what they think the benefit of these reforms will be, and I have no doubt will already be allowing for that in pricing that they are doing currently. So from that perspective, there is benefit already being passed on to consumers in anticipation of the reduced costs coming from these reforms. I think in terms of reporting to the FCA, then there is quite a structured approach that the FCA will expect all insurers to report to, which will encompass a number of factors around average costs, etc., to be able to demonstrate that not only that those benefits have actually come through in claims cost, but also that they've been passed back to consumers. And I think in kind of response, I suppose, to Matthew's comments about 3 years to account, it is going to take a period for these cases to settle. Obviously, people can bring claims up to 3 years, so any kind of frequency benefit does need time to develop to be able to understand exactly what the reforms are going to deliver into our world. But there is a very, very structured approach, and I know that for a fact that the FCA are going to be monitoring that closely as those returns are made, and undoubtedly question and challenge where there are differing views of value and benefit coming through. I think one of the challenges that we face, and we may well talk about it a little bit later, Chris, in terms of part two or other factors, is we know that we work in an industry where sometimes claims costs come out of one area but arrive in another, and there are areas where we will see undoubtedly some activity that could potentially increase costs in the non-injury arena, or even into some of the sort of add-on elements of injury claims themselves. Yeah. So I think it is quite a complex picture that needs to be properly understood and reported to the FCA. But I can't speak for the whole industry, but I can certainly speak for LV, insofar as we have said all along and fully committed to and passing on any and all savings to our consumers. And as I said at the outset, really, the market that we play in motor claims, I don't think any insurer can afford not to.
Yeah, I guess, the competitiveness of the UK market, which is second to none in the world, should, in theory, ensure that happens. I think the complexity will be whether it's directly attributable to the reforms. Sam, too early to tell from your side? Is it a big operational upheaval for Keoghs? What are you seeing in terms of claims coming through the portal?
So at Keoghs, we've engaged heavily on this reform right from the outset. We've always obviously been very supportive of our insurer clients, want to work with them on this. And I take a lot of the points that have been made about the uncertainty. It is quite a big operation. Nothing is perfect straight away. There'll always be learnings, there'll always be kind of teething issues and hiccups with any major IT project delivery. I think that's absolutely to be expected. So wanting to, I suppose, just be constructive about how we move forward, because I think that, we can, if we work together, make a success out of this. From a Keoghs perspective, we're looking at kind of two priorities, really. Is that collaboration piece, working with our clients, making sure that that collaboration also extends across the industry as well, in terms of that cross-sector working. I think that's incredibly important, with making sure that we've got that original objective in the back of our mind. This is for the benefit of the premium paying consumer. So we need to remember that. But also, I think, 5.5 years on, we've got technology now that we didn't have then. And actually, we can use this technology to the benefit of everybody. What can we automate? What stages can we do? How do we help the claimant through that process, through automating bits that we can? But also, making sure that we're there for the assistance for them whenever they do need it. And there's that sort of kind of hand holding, if you like, where a litigant in person is progressing this claim themselves. So I think there's quite a lot that we should be thinking about and working together on. And in terms of kind of what we've seen, I echo what Caroline said about not seeing a huge number of claims. I suppose that's kind of unsurprising maybe in some way. And there's not been a big public information campaign. But ultimately, we have seen some. So what have we seen from those claims that we've had? Well, certainly lots of minor injuries. We've seen this at Keoghs for some time, actually. There's a move away from whiplash. It's almost like whenever there is a policy announcement about any changes, that you kind of see differences in how injuries are presented or how a claimant presents injuries. So certainly we've seen that with the claims that have come through, more minor injuries now. And the exceptional circumstances that attract the 20% uplift, seeing that on quite a few claims, probably more than you'd expect that would be exceptional. frankly. So it, is tricky at this stage, isn't it? Because that's kind of tested by the court. So nobody really knows what exceptional means, and MOJ didn't, and perhaps quite fairly couldn't have defined that. But that's one of the original observations in the first kind of 10 days.
Thank you, Sam. Peter, let's move on to the, very broad topic of unintended consequences. So I think everybody is agreed that what the government is setting out to achieve, reduction in costs for consumers, is a good place for the industry to be heading. It's going to need to be an iterative process as we understand bugs in the system, complexity of claims that aren't covered day one, like any kind of new IT development. And also, to Caroline's point, where when the balloon gets squeezed, where do, if anywhere, additional costs start to emerge that could even offset the benefit here? How do you see that from a credit hire perspective when we look at potential unintended consequences for the market?
I don't see it particularly affecting credit hire at this stage. One of the things that I think needs to happen in order that we deliver the £35, if it's going to be delivered, is clarity about understanding the nature of what drives costs upwards. I mean, the mood music over the last certainly 5 years, if not 10 years, has been that there have been upward pressures on claims. Whether you're talking about fraudulent stuff or genuine claims, whether it's claims rates, accident rates, and the average cost of claims. And that's been reflected in increases in premiums for consumers. So, for example, from the end of 14 to the end of 19, so a 5-year period, pre-pandemic, so not affected by that, we have seen premiums over that 5-year period rise 25%, 4.7% per annum. Now, the argument that would be made in that context is, yes, well, of course they're going to rise because there have been all these upward pressures on claims. Yet, if you look at the period 2013 to 2018, again, a 5-year period, over that period, total claims costs for insurers of whatever type, wherever the balloon happens to be squeezed, have fallen nearly 20%. So I tend to be somewhat cynical about the notion that we're dealing in a competitive market when claims costs fall 20% and premiums rise 25% over a broadly comparable 5-year period. And in that context, the law of unintended consequences I'm completely bemused about because I can't see where the link lies.
Interesting. I think, the one thing we find in claims and premium inflation data, there do seem to be a number of different versions, interpretations. But we'll come on to some of the more specific unintended consequences or potential unintended consequences. But I've got a great question from the audience for you, Matthew. They have chosen to remain anonymous. So, at the same time as telling the public that they are going to achieve a saving of 67 pence per week, just clearly in marketing, 35, 40 pounds sounds a lot more compelling than 67 pence. Are consumers going to be told that in this same unfortunate event of an accident, their PI damages will be reduced by up to 80%? Would that not be a fair thing to do?
Yeah, it's a good point. It doesn't really add up to very much, does it? And I think a lot of our conversation so far has been about whether the £35 exists and whether it'll be passed on. I take slight issue with the idea that it's a particularly competitive market. I do hear this a lot. I think a lot of the competition is illusory because many different underwriters have a lot of different brands. There's price herding, I think, rather than the proper dynamic competition you see in other markets. There is dysfunction there. And obviously the impact of, for example, the discount rate or indeed the impact on the loyalty penalty is probably massively in excess of what we might see from the whiplash reforms. So the £35 a week is really quite minor, possibly. Yeah, the deal for the consumers isn't necessarily a great one, because it's when you need your insurance. And after all, motor insurance is compulsory. It was made compulsory back in the 1930s by Herbert Morrison, Peter Mandelson's grandfather, because of concern over rising numbers of injuries on the road. Insurance is there primarily to help you if you get injured, and that extends to minor injuries, obviously, as well as major. And I think really the conversation should be more about how do we make sure that injured people, be it a minor or a major injury, get the treatment they receive. Now, you can have a philosophical argument about the role of general damages. That is what the law allows for, is if, if you hurt me, you can't take the pain away, but you can give me some money towards my pain, suffering, and loss of amenity. How much? Well, that's been decided over many years by judges, and we have the Judicial College guidelines. The government has, in what is actually a remarkable change, intervened, brought in this tariff, said the tariff numbers might be revised in due course. We may well see tariffs brought in for other types of injuries as well. I know there's concern about, the increased numbers of perhaps psychological injuries or non-whiplash injuries as defined by the Civil Liability Act. But I certainly think, to the general public who as yet do not know about this, they may never know about this because, fingers crossed, they don't have to make a claim. Or if they make a claim, they may not have made one before, so they won't know that this isn't how things used to work. Lawyers will still probably hold their hands through much of this one way or another, or at least some sort of representation. Caroline's 12% figure is very interesting to me. That's how many are currently attempting this as litigants in person. I would have guessed this number would have started high and then dropped back a bit when the reality of negotiating the OIC becomes clear to people, and maybe fall to maybe between 5 and 10%. That's a guesstimate. So yeah, has the public been treated fairly here? Well, I think there's one really important point here, which is that an awful lot of claimants get badged as being part of a compensation culture, part of the problem. They shouldn't be making the claims in the first place. There's a lot of fraud there's a lot of exaggeration, unmeritorious claims. I don't think that's fair. Of course, there's fraud, and of course, people do exaggerate. We don't know how many really, but we mustn't assume it's more than it is. And if we look at different types of injuries, hybrid injuries or psychological injuries, again, if there's a big uptick in any of them, there should be a course of interest. We have to find out why, but it doesn't mean there's something wrong with it. It doesn't mean it's fraud. It could just mean that by squeezing that balloon, as Peter said, in one area, it's going to expand in another. And so you're going to get more people claiming for injuries that previously didn't attract very much. Now, relatively speaking, are going to attract more. It's perfectly natural and reasonable for them to want to claim for those injuries.
Yeah, it's interesting that you talk about the psychological piece. Donna, I'm going to turn to you in a second for maybe let's just start with a couple of potential unintended consequences, because I'm sure there is a longer list than that. But I was talking to a claims director a couple of weeks ago about probably a couple of weeks prior to the go live, and they had been looking at claims data in the lead up to the reforms from particular third-party suppliers, and this is an insurer of scale, so their statistical samples are pretty significant. And they had seen a shift from one particular law firm in percentage of psychological injuries associated with the PI claim, moved from 15% to 85%. And so the perception there in that insurer was processes and readiness and changes, and it may well be, and to your point, it doesn't mean it is fraud, but that is a seismic shift in pattern of claims that is going to drive additional costs, not reduced costs from the new process. Donna, I saw you nearly fall off your chair there. What are your thoughts?
Jesus, 15 to 85% is very high.
He isn't going to help anyone.
No, and funny enough, I've heard some anecdotal evidence around, the mixed injury. So moving away from whiplash and going into other injuries, I've heard of a 30% shift prior to implementation of these reforms. So people preparing to look at it. There's two schools of thought, isn't there? I'll deal with the psych, but just generally on the mixed injuries, because you know that you've got your tariff and your non-tariff damages now. So that's a huge complication in this system, which we have, which I think nobody wants, and it does complicate things quite dramatically. But the 30% shift, so there's two ways of looking at it. If you're not being cynical and you're just thinking, at the moment, if you have a whiplash injury, it's kind of going to be your main injury, and you get your main damages there. So if you have other injuries, say it's a minor injury like bruising, it may not even rank. So you may not really be that interested in it. All of a sudden, where your whiplash injury, it becomes a minor injury because of the amount of money you get for it on the tariff, as I think somebody said, 80% reduction at the lower end. Suddenly your bruising might be more important, or you might be more interested in your bruising. So that's looking at it not cynically. If you're looking at it cynically, you say, I need to make more money because I'm going to be on a deduction here and I only have £200 whiplash, so I need to get money from other things. So it's that kind of, gaming the system to try and get some money out, to take some deductions, to make it worthwhile for you to represent the person. So there's a whole school. The thing on psych, and I think it always comes up because psych is a bit like people say whiplash is, it's difficult to prove. But if you remember last vote, there were two huge firms in the UK that started to do PTSD. PTSD, which is like, it's not your common or garden, a psych problem that you're going to have when you have a crash and you're a bit anxious or nervous about driving. But they were literally going for PTSD on a lot of cases. They had student psych people doing the questionnaires online. It became a huge issue and a problem. And they got away with it for quite a while before it was sort of shut down. So no, it doesn't really surprise me. And I think that's the thing about unintended consequences. And that's why your impact assessment and your consultations are so important at the beginning, because you really need to look at where are the gaps, where are the loopholes here that people are going to use. And you can never fill them all, and you can never know what everybody's going to do, because there's some very clever people out there, including people who are very good at fraud. But I just think on this one, when you look back on the impact assessment here, there were so many holes that we could have seen, that we should have noticed. Not doing part 2 is the biggest hole, because there's still money in the system. There's still a fair amount of money. So I'm not surprised. And I think, we're going to see new entrants into the market. Some of them will be good. Some of them will be bad. They might bring even worse behavior than we've ever seen before, and gaming like we've never seen. So, we all need to be alert. I agree with Sam, collaboration, working together. I was at a fraud roundtable yesterday, looking at what are the unintended consequences, what emerging threats are we going to see around the whiplash reforms. And I think it is important, because, if someone comes out and jumps from 15 to 85% on site, that's not good for the market. That's not going to reduce the premiums. That's not going to reduce claims. That's not going to be good for consumers who may be forced to claim psych when they haven't got any, or it's very minor. So, I think it's good that we have that kind of data, that we have that kind of intelligence about what's going on. And I think we need to use it, and we need to not allow that kind of behavior to get off the ground easily and quickly without shutting it down.
I couldn't agree more, and I think one of the things that goes through my head is the flow and the process of where claims materialise. The UK operates in a market where the vast majority of consumers will report their claim in the first instance to their insurer, or in the case of the broker, where they have bought a policy with, a more independent advice, but still representing the insurer, particularly if I compare it to a market like Germany, where very few claims are reported to the insurer in the first instance. So there's always been an opportunity, to control the provision of services and the supply chain. And it's safe to say that the bulk of our audience, and certainly us on this webinar, work in that insurer space. My fear is that if there is a reduction in the provision of services at the insurer level, it will start to leak back through the process, and that we will see a re-emergence of a larger number of smaller, more nimble CMCs, let's label it today, that will say to the consumer, we can help. We can put you in a very expensive rental vehicle for a very long period of time. We can deal with the repair as well, so ring your insurer up and cancel the claim, and we'll deal with everything. And that the money involved in that, whether it be, to your point, Donna, through a deduction in damages, a percentage of the rental, a percentage of the repair, could lead to a growth in that space. So, Caroline, I can't think for a second that hasn't crossed your mind. Are insurers, in light of this change, going to be less proactive in offering services to consumers, and therefore, open ourselves up to that kind of risk?
No, I don't think we will. I think probably almost the opposite of that. I think we're very conscious that for our customers and our consumers that we don't want to put them into a potential minefield. We want to make sure that we look after our customers, whether that's in whatever way that we need to, or that they need from us. So I think almost the opposite, Chris, to be honest. I think we want to support our customers as much as possible. I think you're absolutely right. There will be almost a race for the customer. And I think that having CMCs, AMCs, etc., able to now pursue injury claims in a way that they couldn't previously gives another opportunity for them to intervene and try and help. But no, I don't think in terms of the service we would want to offer and our desire to do that, whether that's also for a non-fault claimant against our policyholder, we again would want very much to help and support that claimant in the same way as we would our customer. So I don't think there'll be a change to provision, but I do absolutely think there'll be a race to get to those claimants or consumers first. And I think that's the challenge that we face.
There's a race that we're all used to, and just looking at the questions coming in. Angela, good morning to you. Hopefully that answers your question without even having taken a look at it. Another question that's come in from the audience, I'll put this to you, Sam. So when we talk about that provision of services, and we talk about the kind of legal expense insurance market, which is a product a consumer buys typically at the renewal point of their insurance to enable the support services they may or may not need should they have an incident that involves injury. Do we see more consumers are going to have to buy legal expenses policies to access these types of services, Sam?
It's a really interesting question, and one I think that everybody's been thinking long and hard about, because it's I don't know, what is this going to look like? Will they need it? Will a claimant be able to do this, put a claim through themselves? Will they need help? Legal expenses insurance has been something that the government historically has been really, really keen to promote. They've always wanted that as the kind of solution, I suppose, to legal aid, which was removed however many years ago now. So it's something that they have wanted to encourage. The market at the moment, I don't know, it's a bit early to tell, isn't it? Don't we need to see how easy or not it is for a claimant to be able to progress the claim? I think the public perception is very, very important, because as we know, with motor insurance being so competitive, when you have a customer that goes onto a comparison website, wants to buy some motor insurance, you will go to the cheapest one first. Well, we'd hope that none of us do, because we kind of understand a little bit more about what we're buying. But, with a compulsory insurance product, you are naturally going to have a very, very price sensitive consumer. And that is the problem there, because you've got the extra kind of options, don't you? Do you want legal expenses insurance? does a customer, are they interested? Do they understand it? Do they think it's worth what it is? I'm not sure about that. I do think there needs to be a wider educational piece around this. But ultimately, I think this is a market that will kind of ebb and flow as time goes on, as we get a better understanding of what the perception is for a claimant to be able to pursue the claim themselves, of how the claimant representative market kind of consolidates or not, and where ultimately where the litigant in person might fit in. Chris, I think you're on mute.
Oh, so I am, sorry. Take a look at a few questions from the audience. We've got some very detailed ones. Here's a very technical one, so I'll open it up to the floor for anyone that chooses to answer this one. As a claim representative working on behalf of someone injured and using the OIC portal, how important is the B2C claims signature process in speeding up the pace of getting signed agreed claims back and also helping the overall digitization of your claims process? Or is this process still manual? Anybody like to shed any light on that?
Can I call a friend?
I was going to nominate you, Donna. So
I honestly don't know the answer to that. That's far too deep. I'd have to ring Alan Hayes to ask him that, but I don't. That's far too detailed for me. Sorry,
So
I have to find out.
Yeah, I guess that was meaning about actually signing up the customer to engage the services of the representative. And you know, I guess that takes time. Does that slow the process down? And
it's a different process to what we use, because we're kind of a corporate, so we're doing it in a different way. So I don't know the answer to that question because it's not how we do it.
Candor, as I would expect, but we will commit to returning to all of these questions following today's webinar. So we've got a comment from one of our audience members. I hope we're going to discuss the CHO CMC behaviours on driving costs up. Our claims currently low on the OIC because the CHOs are controlling the process for their clients and building claims, litigation costs, especially on liability decisions within 30 days. Savings can only be passed on if savings exist. Peter, any thoughts on that?
Well, it's interesting that the CMA did their review back in 2014, for those that can remember that far back. And one of the subjects of their review was the impact of credit hire on private motor insurance premiums. And their exercise quantified the cost at 58 million on just under 26 million private motor insurance customers. That works out at £2.26 per policy, with an average policy probably of the order of 400 odd pounds. So you're talking about 50p. In addition, over that period, 5 years since, policy premiums have risen by about 25%, whereas, for example, GTA rates, which have been used to settle most claims within the sector, have barely moved. So on that basis, that £2.26 has probably already fallen to about £1.80. So I struggle to see how it can be argued that CHC's credit hire companies are pushing up the cost of claims when we're talking about a figure of about £2 on a £400 premium. So by all means, look to take steps to save money, but you're going to have to do something dramatic when the arguable premium is barely £2. And this is this is the CMA's own calculations. It's not my data.
I guess the cost of all these things, it has to be proportionate to the cost and effort involved of implementing. So Caroline, just a quick one back to you, which is when we talk about the 35 to 40 pounds per annum saving, which is a compelling reduction in the cost of motor insurance, which is a huge part of people's day-to-day expenditure and a mandatory one as well. So I think, even more important to identify savings for consumers there. What does that assume in terms of the percentage of claims that will be pursued by consumers or pursued through the portal or the new regime? Because we've talked about numbers such as 12%. Does 12%, if that continues, play through to the £40? Or if we see an 85% shift to psychological, is it all going to be an unintended consequence that outweighs, the benefit?
Yeah, I think it's a really interesting question, because clearly whether or not the claimant is represented or unrepresented, the ability to pursue the legal costs is still not there. So therefore the lack of, I suppose, legal fees being paid as part of that saving that equates to the £35, I think, is being quoted at the moment. So yeah, there are a lot of assumptions around. I suppose back to the unintended consequences. We know, I think in the industry now, phrases such as race for 5k, race for 10k, being used in terms of getting back into a cost-bearing situation to bring fees back into the claims cost. But yeah, it does assume that tariff damages will be applicable on a good chunk of soft tissue injury claims. And as we know, sort of over the last 5 years, the definition of soft tissue is narrowed quite considerably to perhaps where it was at the outset. So there's lots of moving parts associated to it. I think the 5k increase to 5k on the small claims track for injury, it is probably the driver of the biggest part of the benefit, which is the reduction of legal fees. But equally, tariff damages in themselves bring in additional benefit. I think the unknowns, the uncertainties around that kind of 35, 40 up to £35 benefit comes when it comes to things like the tariff plus non-tariff. How many of those are we actually going to see? We mentioned earlier around some of the behaviours that appear, and to be seeping in even pre-reforms on some of the medical evidence that was referenced. We've seen, that we've referenced the psychological elements and how they're kind of creeping in, and that has an additional cost in the tariff world. So I think that there's many different moving parts, but the assumptions around what proportion of claims will go into each of those buckets is clearly critical to the delivery of the amount of benefit that gets passed back to consumers.
Yes, that makes a lot of sense. Just an amusing comment from one of our audience members, Alan Clark. Let's be honest, in 3 years' time, we'll be asking why England and Wales no longer have the weakest necks in Europe, but yet seem to be the most prone to tinnitus and wrist lash. Not a term I've heard before, post an RTA. So let's move on to talk about part two. So I'm going to ask Sam to tell us what part two is and whether it's going to happen.
Well, I can help with the first part. I'm not sure about the second, but I'll try my best. So part two was always supposed to follow part one of the original government consultation in 2017. And this examined all of the other parts around the claims that we kind of don't see included. And I suppose the main one, and I suspect the one that we'll focus on today, really is credit hire. So it is looking at the credit hire market, credit hire aspect of claims, and how that fits into an injury claim. And as we know, that's out of the process now. It's not kind of naturally joined up through this portal. And so I do think that there is quite a lot of recognition and agreement across industry on both sides that actually, part one would not work as well as it could without part two, because credit hire is a very important part of the process. So to attempt to answer the second part of your question, Chris, in terms of when we might see it, it's kind of 4 years on now, isn't it, from when we had expected it, that part two government response to the original consultation, because everybody was asked the questions on credit hire and rehab, which also form part of it. I have not heard that it will be with us anytime necessarily that soon, but maybe towards the end of the year, early next is very unofficially, things that I'm picking up.
Thank you, Sam. John Gibson told me you'd commit to a date there, but I'll pick that up with him later. Matthew, I saw your hand go in the air there, so I thought I'd draw you into the conversation. Yeah,
I asked the MOJ about this because obviously they did previously commit to come out of part two sometime after the launch of the OIC. The MOJ told me earlier this week they still considered doing that, but at the time it was 2 days after implementation, and they said it was a tad early to be considering it. We have considerable amounts in relation to monitoring and bedding in the new service. We'll return to part two when the team has the capacity to do so. I'll leave that whatever it may mean. I think exactly to go back to what Sam said, it's so many years since the consultation was first undertaken. I would be very surprised if the government came out with any substantial proposals based on the consultation responses. A lot has changed in that period and how the market has moved on, the claims numbers and all the rest of it. So I think it would probably be a pretty bold move by the MOJ to come out with anything substantial. It may well consult again. The other element of it that Sam mentioned that I think is important actually is rehabilitation, which is not part of the portal process at the moment. But obviously from the point of view of injured people, back to my point about you can have a philosophical argument about the role of general damages, but no one on any side of this debate has ever said that people shouldn't be rehabilitated if they have genuine injuries. But I think there is things we could be doing on that, and I represent many rehabilitation companies, and we are working with colleagues at Foyle and elsewhere to try and see what more can be done to standardise processes, have perhaps slightly awkward conversations about pricing, but reduce the friction that exists there and make sure people are rehabilitated as quickly as possible, which is in absolutely everyone's interest, especially the injured party, but also the insurers who are picking up the tab, and of course the impact that early intervention can have on prognosis period. So I think that's an element of what we call part two that I think is worth discussing a little bit more. When I was looking this up early to see the longest gap between sequels in cinema history, and it's 49 years between Peter Pan and Return to Neverland. So there we are, 49 years. MOJ, that's your target. Try and make 50. Raise your bat and see if you can take that long.
Very good analogy, and let's hope it happens before then. Donna, part two, is it necessary as a kind of package of reforms to stop helping or stop the balloon being squeezed?
Absolutely. And I think, interestingly, we talk about collaboration. We were totally aligned in the industry on this. Both sides said to the MOJ, it has to be a package. If you want the best outcome, it has to be a package. So I think both sides are devastated that it isn't a package, but we just have to get on with it. I think in terms of what Caroline was saying, and I agree with her that the savings here in terms of the insurers are the reduction, removal of fixed costs up to £5,000 and quite a big reduction in tariff damages for whiplash. So that's their savings. But if you have those on one side and on the other side, you have the part two not done. So you have the potential for bad people to increase credit hire and credit repair, run up rehab costs, gain mixed injuries, use exceptional circumstances in every case. So you get an extra 20%, bring in psych 85% more than you used to. All that stuff will just erode all those savings to the point where how are we going to get the £35? Because, and I think that's the worst scenario in the whole world for us, isn't it? That we go through all the pain of putting these reforms together, of implementing them, of trying to explain to people and trying to represent them in some form. And then at the end we go, what was the upside? You know, what did we do here? What was the success? And I think that would be the worst case scenario. So, you know, I don't want to dwell on part 2. And I agree with Matthew as well, that it's been so long since this consultation. You couldn't just kind of put them in now. You'd have to revisit the consultation, I think, in my view, and do it again on part 2. But, you know, and I have heard the MOJ, and David Prockin has said he will look at it. I just worry, you know, we're in the middle of a pandemic, we have Brexit, we have a lot of stuff on our plate. So, you know, when, and it'll be too late if it's years and years. I just wanted to say one other thing. I very rarely disagree with Sam fundamentally, but in terms of LEI, and I have gone on about this for quite a number of years in the run up to these reforms, I think there should have been a customer awareness campaign around LEI, because for me, and I'm old enough to remember when LEI was, you know, a very important product, and if you had it, you got represented and somebody helped you with your claim. I can't think of a better scenario than now, when this hits you and you find you're on the OIC on your own and you go, oh, thank God I got legal expense, because I can ring someone, I can ask them to take me through it. I can get help here on mixed damages, etc. But also it's protecting them from bad people, because if these bad people are coming into the market thinking, oh, this is really lucrative, we can clean up here, we can make money on credit hire, we can do this, you know, we'll show them how this is done. If you've got LEI, you're protected, you're looked after by your own insurer, and there's SLAs in place and you have to be looked after properly. So I think it is something that should have been promoted more. I know there was this idea that everyone was going to do this themselves, but I think as it's unfolded with the rules and the protocols and the 60-page guide, I think we're becoming more and more aware that probably people are not going to do it themselves. And if that's the case, they need representation, and we hope that to be the best representation that they can get in terms of protection and in terms of the industry not being gamed. So I just wanted to throw that in at the end.
And that goes to Matthew's point earlier about Mr. Mendelssohn's grandfather, which is something I've learned today in the introduction.
Yeah, I didn't know that.
Mandatory motor insurance. Matthew, I saw your hand go up again there on.
Yeah, it was just quick on LEI, because I mean, I have a lot of LEI manufacturers, distributors and so forth in my membership, and it is a very important product. I think it's a misunderstood product. It's a very widely purchased product. I mean, possibly the tens of millions of both motor and home policies exist out there. But exactly, I think Sam said earlier, the MOJ has said it supports it. The CJC has done the same. The Legal Services Board has put greater uptake of LEI as being one of its strategic objectives for the next, I think, 3 years, which may be quite ambitious. But we do need to be talking to consumers more about this. There are interesting international comparisons. If you compare us to, say, Germany, where LEI is a much more used product. It's a rather more expensive product because they're a more litigious society than we are. But certainly, I think as this beds in and consumers begin to understand a bit more the value of LEI, the increasing value of LEI, we may see better products, more competition, and better consumer awareness. But I think we've all got something to do in that as well as the regulators and the MOJ and the CJC, to say you need to look again at the value of this product and how important it can be to you at the point of claim.
Yes, that makes sense as well, Matthew, for sure. I'm going to carefully tread on a dangerous ground here in relation to my own personal views. So we touched earlier, Caroline, on insurers have the ability to control the majority of claims. The UK benefits from really high conversion into approved repair networks, the great services that the body shops do to support that, and consumers report claims to their insurers. As a result, that is where a vast amount of credit hire services are fulfilled and directed from. And there's a comment in the chat from, I'm going to guess it's an insurer, that is saying, based on their statistical evidence, credit hire costs have continued to increase. We have obviously had a global pandemic where it was quite hard to get cars fixed in a timely manner, but I'm assuming they're looking at normalised data, and that it's of a bigger detriment to £2 per policy, which again, I think makes perfect sense. Do you see, and when we look at credit hire, I think sometimes we fall into the trap of talking about averages, because I think there are hugely different cost basis, average invoices, for reasons of sector-specific approaches. But I guess my question to you is, do you see a big difference between different third-party suppliers and the costs that are presented to you as an insurer? And if so, should insurers be held a little more accountable to the costs that they're putting into the market, not just the costs that they are being presented?
Yeah, again, really interesting question. I mean, I think we see a reasonable difference between credit hire organisations, both in terms of periods. I suppose is probably the biggest difference that you can see, because the vehicle is the vehicle, and we do see that. And equally, we know that a number of insurers source customers into credit hire where they're in a non-fault scenario, and that there is a whole model around that. I think, though, it is a very challenging scenario to unravel that without some kind of legislation around it, because as we've referenced, whether everybody on the panel agrees it's a competitive market or not, whilst that is happening in some organisations, it's very difficult for that not to become the norm across all insurers or organisations. So I do think there's an opportunity there for sure, but I do think it requires legislation as opposed to goodwill from some, but not all insurers, to remove some of that.
And when we talk about legislation there, would that be more of a regulatory piece? Because we're not talking about consumers' rights to claims. We're talking about insurers doing unto others as they would wish to be done to themselves, I guess, a little bit. Yeah,
I think there was a hope that the CMA review would bring some level of I don't know, use the word fairness, but consistency maybe into that arena. But I think that is the only way that you will solve that problem, is by doing that on a regulatory basis.
Yeah, I would hope so. So we are coming to a close. Wow, an hour and a half is going to have passed in a flash, and I'm sure, as I mentioned earlier, this will be first in a series as we see these changes unfold. Hopefully, our second webinar, you'll all be able to join us again so we can keep the conversation consistent, and hopefully it won't take 49 years for us to put that together. But let's go round the table for some closing thoughts, wishes, hopes, fears, concerns. I will go back to our original order. So Sam, why don't you kick us off with your thoughts for the future?
Sure. Thanks, Chris. So kind of parting thoughts, really. Just a quick one on LEI. I mean, I agree that it can play a part. I think the educational piece around that is quite important. So it's not that I don't support it. I suppose it's just being aware of the reality that it's not kind of well understood at the moment, and with the reality also that the motor insurance customer is very price sensitive. So, just being realistic about that as a solution. But I think customer choice is really important. So, whether an LIP puts the claim through themselves, whether they appoint somebody, use their LEI, I think that choice is incredibly important. And I suppose my kind of overall kind of parting comments are just that, yes, there are some potentially some issues that need to be worked through with these reforms, but let's work together on them. Collaboration is really, really important. So if we do that and try and use technology to our advantage, well, then, hopefully we'll get back to the original objective and my comments right at the outset, at putting the customer, thinking about the customer as part of these reforms, but also making sure that the claimant is well looked after as well.
Thank you, Sam. I was just looking at a text I've received from John Gibson there. Peter, closing thoughts from your chair, please.
So, closing thoughts in relation to part one are that I think there needs to be a period of bedding in. We can speculate here in week one till the cows come home, but I think we probably need a decent period in which to see the extent to which the intended benefits of the OIC come about, whether the savings materialise, whether the balloon gets squeezed in other areas, as some have speculated. And I also think in this context, we need to be past the impact of Brexit and the pandemic. So I think there's a little way to go before we can look back and say part one either has or hasn't worked and has or hasn't delivered the promised benefits. I do worry for insurers that £35 may well come back to haunt them unless they're able to demonstrate to the benefit of the consumer that it has actually been definitely delivered. In relation to part two, I think there probably needs to be a further review, given that a lot of the information is considerably out of date. And then the question that will arise is, what is the problem that you are trying to solve? Given that we have seen over the last 5+ years, ignoring the impact of the pandemic, a substantial reduction in the scale and cost of claims, and this is the ABI's own data, I think there'll be a question whereby one ought to pause and say, are we looking for a problem to solve that doesn't really exist? And I know that there'll be those that will point to fraudulent activity and exaggerated claims, but I think there we do need cogent, independently sourced data to quantify the scale of the problem before we say that we need regulation or any other form of solution. Because I think that the industry has demonstrated successfully, going back to Sam's point, that collaboration and cooperation has served to remove most of the friction that existed in the industry in the past.
Yeah, I would agree with that. Caroline? And then I'll come to Donna and we'll finish with Matthew.
Yeah, I mean, I think I would echo the importance of collaboration. I think we're going to be in a very uncertain period in terms of understanding data. I think it's important that we truly understand data as an industry, and that we don't either sit in isolation on a lot of things, and that we very quickly articulate where, if there is balloon squeezing, that we spot it and deal with it, because absolutely to be able to deliver those savings, I think is what we're all saying we really want to do for consumers and customers, them at the heart of literally everything that we do. That should be our aim. So I think it's that let's understand, let's let it develop, but let's respond quickly and hopefully collaboratively to be able to deliver what these reforms are intended to deliver. I think in terms of part two, for me, I do think it's really important that is brought back. I totally agree that it's moved on and we need to do more sort of understand around it, but I really do fear that will be where we perhaps see some of the eradication of the benefits. So very supportive of part two being pushed forward.
Thank you, Caroline. Donna, hopes, aspirations, apart from Liverpool doing a better job of defending the title next year?
Well, when we have all our people back from injury, I think we'll be fine.
We do.
And we still have Klopp, so
I'm excited.
There's Klopp behind me here. But I think I'm going to be echoing some of the stuff that's been said, but it's kind of a twofold thing for me. So firstly, in terms of the customer, it's important to them that we do try to make this work and we keep an open mind, and that we have a will to do that. And we do that as an industry. So we do collaborate on that and we make it work the best we can. I'm hoping the MIB will respond to some of the issues and again, work with us. Going on to the second part, I think, we need to be spotting the bad entrance, the bad behavior, the gaming, and we have access to quite good, brilliant MI and data. I'm sure this new portal must have brilliant data as well. It's brand new. It's been an expensive thing to put into place. So I'm thinking, if we've got all that data, we've got to share it and we've got to look at it. And instead of, just letting people get on with things and do things. I mean, in the travel claims, it went haywire, it went mad, and then it was shut down because they saw the abuse, they saw what was going wrong. And I'm not saying that all those claims were wrong, but there was obviously some abuse going on there. So that's my wish, is that You know, we make it work the best we can, but we also don't put the red carpet out for bad people and bad behavior who see this industry as a way, you know, to make money or an easy target. Because at the end of the day, it's our industry and we should try and make it work the best we can.
I agree. Thank you. Matthew.
I agree with a lot of what's been said. I think we all have to watch behaviours on all sides and gaming the system. And I don't like the demonising of claimants just because someone has a temerity to make a claim. You know, expressions like wrist slashed, I think are very unhelpful, to be honest. And it isn't really what you want to be seen to be doing for your customers. But I think just one final thing to conclude on, which we haven't mentioned. I think COVID and recent history has shown that we can put a rocket booster under some technological progress that we can make. We haven't yet discussed alternative dispute resolution. That was originally part of the plans for all this. I think it needs to come back. I think the Master of the Rolls is very keen on that sort of solution. We're working together with insurers, claimant firms, and ADR providers to show how it can benefit all sides, get claims progressing much faster and to everyone's benefit. So I think let's look what we can do together, back to that collaboration point. And I think ADR is a great opportunity for us to do exactly that.
Yeah, I was going to say that there are a number of questions, both very technical and I think touching on things like ADR, medicals, etc., that we do need to pick up again. So I'm going to put you all on the spot and ask if we can reconvene maybe in 6 weeks' time and pick up some of the subject matter areas that have been mentioned today. I, for what it's worth, my own view is that there is an opportunity for the industry to continue collaborating. There are good examples of collaboration between insurers today when it comes to you know, how non-fault claims costs are controlled, mitigated, and have an element of parity. There are also some really bad examples where I think, you know, insurers are putting extremely high cost claims into the market and expecting to benefit from low claims coming back in. So I think, you know, I think to your point, whether it be regulator, whether it be CMA, fingers crossed that the industry continues to collaborate and fixes what it can itself without needing to be hit over the head with regulation, you know, beyond which it is reasonable in terms of the scale of the problem. We've seen some great collaboration during COVID through the industry, whether it be keeping people mobile, keeping the NHS, the blue light going. We're nearly at the end of the tunnel, fingers crossed. Matthew mentioned earlier we hope to see you all and our audience on the 2nd of July. And I'm sure which will be a much warmer Connaught Rooms to safely raise a glass. And I very much look forward to that. But I thank you all for the support you've shown us and an incredible job that our partners have enabled us to do and the team at ILC has done. And with that, I will bid you farewell and wish you a good afternoon. Thank you, panel.